May it please the court, my name is Hassan Ali and the party that I will be representing today is the Ministry of Energy, that is the defendant in this case. Your Honour, the legal question this preliminary reference seeks to answer is as follows. Where an arbitral tribunal issues an anti-suit injunction and thereby prohibits a party from bringing certain claims before a court of a member state, does the court of that member state have the right to refuse to recognize such an award of the arbitral tribunal because it restricts the court's rights to determine itself whether it has jurisdiction to hear the case under the rules of jurisdiction in the recast Brussels regulation? Your Honour, I will be discussing the facts of the case. This case involves three parties mainly, namely LAW011-6Assignment, BioSAR and the Ministry of Energy, France. The Ministry of Energy initiated proceedings in the French tribunal against LAW011 for amending the price agreement with BioSAR in a way which was unfair to its interest. Subsequently, BioSAR initiated an arbitration based on the shareholder agreement in the Stockholm Chamber of Commerce, also referred to as the SCC. The SCC held granted an anti-suit injunction and ordered the ministry to withdraw its request for setting a fair price for gas with BioSAR in front of the French court. The French tribunal, on the other hand, upheld the claim made by Ministry of Energy and decided that any matter relating to shareholder agreement was within their jurisdiction and arbitration could not be carried out in accordance with the French law. Your Honour, the respondents appealed to the French Court of Appeal. BioSAR also brought a claim for the recognition and enforcement of tribunal of arbitral award granted by the SCC. The Court of Appeal rejected the arbitral award based on Article 52A and 52B of the New York Convention respectively. Your Honour, it held that denial of jurisdiction to the French court was against public policy and could trigger Article 52B of the Convention. Both parties then appealed to the French Supreme Court, which is also referred to as the Court of Cassation. The court stayed proceedings and referred the legal question to the Court of Justice for the European Union for a preliminary ruling. Your Honour, we will be discussing the documents of this case. The following documents will be relied upon by the respondent. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also referred to as the New York Convention. The regulations of the European Union 1215/2012 of the European Parliament and of the Council on Jurisdiction and the Recognition and Enforcement of Judgment in Civil and Commercial Matters, also referred to as recast Brussels regulation. And the Gazprom case. Members of the Honourable Court will be discussing the tests to be applied in this particular case. The test upon which these arguments are based is to be found within Article 52A and 52B of the New York Convention. Members of the Honourable Court will be discussing the issues and then having a detailed discussion on each of these issues. The issues, what are those issues, Your Honour? They are: how are arbitral awards recognized and enforced? What is the distinction between anti-suit injunction granted by the courts and those granted by arbitral tribunals? Can a court refuse to recognize and enforce an arbitral award based on the fact that it would infringe its own jurisdiction in such a case? Now we will be discussing each of these issues in detail. The first issue, as mentioned before, Your Honour, how are arbitral awards recognized and enforced? The respondent contends that the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention, was signed in 1958. It is applicable here as the Convention applies to award made in any state other than the state in which recognition and enforcement is sought, which makes it relevant in this case as the arbitral award was granted by the Stockholm Chamber of Commerce and BioSAR wished to enforce it in France. Article 5 of the Convention becomes relevant as it is the basis upon which the French Court of Appeal has refused to recognize and enforce the arbitral award. Article 5.2 states that any arbitral award may not be recognized or enforced if the member state does not allow such matters to be settled through arbitration and if enforcement is contrary to public policy of the member state. Your Honour, we contend that matters relating to unfair price agreements fall within the jurisdiction of the French courts and cannot be settled through arbitration, due to which exception under Article 52A applies. Article 1514 of the French Code of Civil Procedure (CCP) states that courts within our jurisdiction will only recognize and enforce arbitral agreements if they are not contrary to international public policies, and the onus to prove that this exception does not apply is on the party relying on the arbitral award. Your Honour, we contend that under Article 52B and Article 1514 of the CCP, the public policy exception will apply as the shareholder agreement has the potential of affecting state interest, a matter which cannot be settled through international arbitration, but through the judgment of court within our own jurisdiction. Your Honour, The next issue is, what is the distinction between anti-suit injunctions granted by courts and those granted by arbitral awards? Members of the Honorable Court, we contend that this issue has been dealt with under the Gazprom case, wherein the Court of Justice of the European Union stated that anti-suit injunctions issued by arbitral tribunals does not impinge upon principles of Brussels regulation, since arbitration was excluded by its scope. Your Honor, thus, our assertion is that anti-suit injunctions are regulated under the New York Convention. Considering that anti-suit injunction has been granted as part of arbitral award, the same rules under Article 5.2 will apply. The shareholder agreement has the potential to adversely impact state interest, which it has done so well, and thus public policy necessitates that French court take control over matter as opposed to depending on arbitration agreements. Your Honor, under Article 5.2b, we contend that anti-suit injunction preclude us from bringing this matter to a French court for resolution, as public policy is involved over here. The next issue, Your Honor, is that can a court refuse to recognize and enforce an arbitral award based on the fact that it would infringe its own jurisdiction in such a case? Your Honor, we contend that the Brussels recast regulation allows court to determine the jurisdiction with regards to dispute resolution. Article 4 establishes general jurisdiction, whereas Article 7 allows for a special jurisdiction to be identified in certain situations. However, we also recognize that the Brussels regulation excludes arbitration agreement from its scope and clarifies that for the purpose of any arbitration agreement, the rules from its scope, the rules under the New York Convention will apply over here. Your Honor, this means that any foreign award made under an arbitration agreement are regulated under the New York Convention, and thus the exception under Article 5.2 becomes relevant to this issue as well. Your Honor, under Article 5.2a, French courts can refuse to enforce an arbitral award if it is related to a matter which cannot be subject to arbitration under Article 5.2b. It can refuse to do so on the basis of public policy or on the basis of state's interest. Your Honor, we argue that both these exceptions apply because under Article 5.2a, the judgment of the Court of Appeal becomes relevant, wherein it has held for us and stated that the matter must be decided by a French court, as it cannot be subject to arbitration under the French law. We also contend that considering state interests are at stake, public policy requires that French courts determine their own jurisdiction, a matter which is allowed under Article 5.2b of the New York Convention. Your Honor, now that we have discussed all the issues in detail, I'll come on to the concluding para. We argue that under New York Convention, mainly Article 5.2a, we have the ability to refuse enforcement of an arbitral award based on public policy and on the basis that a French court has already established that the matter is such that it cannot be made subject to arbitration. Your Honor, I rest my case. Thank you.